Okay, so that takes us only through Thursday. And we're still on Thursday. And now we're looking at a real tag team.
Hello, this is Paul Hood, and I'm with my frequent co-collaborator, co-conspirator, maybe even sometimes Ed Morrow, and we're doing a session at this year's Notre Dame conference that is essentially a subset of a 3 90-minute webinar series that Ed and I did on the comprehensive coverage, tax and non-tax issues relating to modifications, terminations, decantings, and commutations. In this session, we have 60 minutes and we intend to cover the primarily the tax or predominantly the tax consequences. We're going to quickly cover what decanting is, and then we're going to look at, what are the transfer tax consequences? Um, can things be made effective retroactively, and when are you successful doing that? What risk does the beneficiary take in consenting to a trust modification or decanting? Are any gifts being made? So, Ed, what else are we going to cover?
And along with that, I do think we want to touch on some asset protection cases in a similar vein. And I think we want to pay attention to those as well, because the bankruptcy and creditors don't necessarily have to follow what people agree to amend their trust to do either, right? And then we'll go into affecting GST exemption as well as gift and estate tax. And there, there's been a couple of CCA chief counsel memorandum that have come out in the past few years. One in 2021 regarding Q-tip commutations. Of course, the hottest ticket in the last year has been the CCA that came out at the end of 2023, and it shouldn't be as much of a surprise as it was to the practicing community. It's a little bit of a shot across the bow of how the IRS might be looking anew at the tax effect of trust notifications, I think, Paul. But it's what we want to do is dig in a little bit deeper into how much of that CCA is based on real authority and how much of it is just a scare tactic by the IRS. Believe it or not, there are some prior rulings before the CCA and in even some court cases. We want to talk about those to kind of glean through that CCA. How much should we be worried about that CCA, of course? And there's also some private letter rulings that came out in 2019 that should really scare you on trust commutations. Commutation, of course, is the early termination of a trust. And so we want to work out what are the income tax ramifications of a commutation. And there's a really scary provision in section 1001 of the code, specifically 1001E, of which in which some cases the current beneficiary, upon termination of the trust, might be deemed to have a taxable sale with a zero basis. And I call it the zero basis apocalypse. And we want to pay attention to that for any trust terminations. Believe it or not, there are some cases when there may be income tax ramifications of substantial modifications as well, and not just non-judicial settlement agreements where everybody agrees. We want to cover the commutations, but also when might decanting be the same as a modification? And there was a little bit of a scare in that CCA where they implied that in many cases decanting might, result in the exact same result income tax wise as a non-judicial settlement agreement might be. We'll talk about triggering of gain when changing from grantor to non-grantor trust and back and vice versa, because that might be a common thing people might want to do in a trust modification, right? So we'll talk about when might a modification that doesn't terminate a trust still trigger gain. There's some private letter rulings out there that you ought to know about, at least to warn your clients about, where even a substantial modification that substantially changes the economic interest of the beneficiaries may be a taxable event under section 1001 of the code. There might be some situations where commutation is still a good thing, but we want to kind of parse out and know what to warn our clients about. And so we want to know when there might be some instances where it might disqualify a quest and some different things like that. And in a nutshell, Paul, I think we just want to make sure that people are aware there's a lot of uncertainty, particularly in the income tax ramifications about this, that we shouldn't be too confident in the answers. But there's some different techniques that we're going to go through in the summary to get around to the same thing with less danger, basically.
Well, I will tell you that anyone who is not familiar with those 2019 private letter rulings, which the IRS plainly says they weren't hiding anything, the commutation is a taxable event, an income taxable event. And right then and there, that and we give examples. And in the appendix, I wrote what we call the CYA letter, which is a letter to a client who is a beneficiary of a trust being commuted about what the potential tax consequences are and where the uncertainty is. Because in one of our examples, it was a $20 million gain and the tax was like $4.65 million. Well, clients are going to be upset if they get that bill and they weren't told about it in advance. So Ed, I think hopefully if that doesn't whet your appetite to come hear us in South Bend, I don't know how I can do it any better than that.
Well, we'll look forward to seeing you all there in September.
Yeah. Most of the time people talk about early termination or commutation or modifying what we call private trusts. There's a lot of people who have charitable remainder trusts. And the problem with charitable remainder trusts is the charity doesn't get anything till the client dies. And the client says, I would like to help out my charity today. So why don't we terminate the charitable remainder trust early, and then I'll get the present value of my future income, and the charity will get the rest, which is the present value of the remainder interest. And what Paul and Ed are going to show you is you could end up having a very substantial capital gain to report when all you're doing is dividing the trust assets between yourself and the charity. So they're going to point out some very practical problems that you can avoid if you know about them in advance. Thank you.
This is a real issue with they're talking about. The recent CCA was, as they described, a shot over the bow from the IRS, suggesting to practitioners that we should not assume that any kind of trust modifications, decanting or otherwise, is going to be free of tax problems. And very timely, very important. And again, with the looming deadlines of pre-2026 planning, we may have the desire to change trusts and clean up things and use GST exemption where clients don't have other better uses for it. And all this is going to have to be kept in mind with that planning.
And I think we forgot to mention that Jerry is in touch with every speaker before, during, and after the presentation to make sure that they cover what Jerry thinks is important to cover, and that these are going into white papers. So every one of these presentations includes not just some PowerPoints and a transcript, but a solid white paper that you're going to be able to take back to your office and learn from both during the program and after. So hats off for all that, Jerry. Next, now we go to Friday. I mean, how much have we learned for Thursday? That's so much to cover. And then Friday, overcoming too much value in GST vulnerable trusts.